I owe you guys, I think, 45 minutes, which I'm happy to give you. I will find somewhere to put 45 minutes if you need it.
I appreciate, Your Honor. Moving forward, I'd like to present defendant's proposed exhibit Z as impeachment evidence. Does the court have that audio recording?
How do we pull that up, Madam Clerk? An audio recording? And then it'll show up on Blue Jeans? Okay. I think we should play it in jabs. Can we play it in jabs?
Council can try to.
Okay. Mr. Eckerman, are you able to play it via screen share?
I'm going to do my best. Last time, my screen share didn't work super well. I will try right now.
And I just want to state this before you commence, Mr. Eckerman. I'm not sure if that is the best use of your time, if there is no pending order to show cause and an accompanying AWOD versus Wright affidavit, but I'll let you present your trial the way that you'd like to.
Very good, Your Honor.
We can't get it to work, just move on.
The court able to see my screen?
Yes, counsel, absolutely. Thank you.
Mr. Baptista, you testified just before the break that you've never recorded one of the telephone conversations between you and your daughter. Is that still your testimony?
Not what I said.
Okay. Since the April 2018 order, have you recorded telephone or FaceTime contact between you and your daughter?
No.
I'm going to go ahead and play this recording. Your Honor, it's unfortunately it's not working, so we'll go ahead and move on with that.
Hang on, counsel. Does Mr. Kelleher stipulate to the admission of Exhibit Z, or is his own exhibit, or no?
Sure, Your Honor. I have no problem if the court wants to accept it as an exhibit. As an offer of proof, what it is, it's a tape of the child telling dad in person and being taped during a visit that she had. It's not a violation. It contains hearsay, right, potentially. So we weren't going to admit it, but we produced it. So, but I have no problem admitting it, Your Honor. If the court wants to hear it on its own, I'm fine with that.
Well, as far as evidentiary rules, in-person taping when you're in a room together is permissible evidence, but phone taping would not be approved because we're a one-party consent.
Well, just because it's a child, so I know that that's the issue, right?
Okay.
Okay.
And Your Honor, we believe if once the court is able to listen to it, that in fact it's very clear that it's a phone or FaceTime contact. But in the interest of time, I would like to move on if Your Honor is okay with that.
Sure. Whatever counsel prefers.
You were ordered to attend FMC mediation last summer, right after the initial hearing on your motion. Is that correct, Mr. Baptista?
For the initial hearing, I'm sorry?
Yes, the first hearing on your motion.
Yes.
Okay. And the summer of last year, you did not, in fact, attend that FMC mediation, correct?
Correct.
Okay. When you first told Ms. Dow about your plans to go to Missouri, you asked her if it was okay for you to keep Emma from February 28th to March 25th. Is that correct?
I don't remember the dates.
Is that timeline more or less sound right?
No, I think I offered to give her February 28th to March 25th, if that's what you're saying.
Okay, and then when would you have Emma after that?
It was prior to that, it was January to February, so that would be my 30 days. And then I drove out to Missouri on February 28th.
Okay. Did Ms. Bao agree to your request for you to have 30 days and her to have 30 days?
She did not.
Okay. And you weren't particularly happy about her not agreeing, is that right?
Yes?
Okay. And on April 2nd, one second. Please turn to our Exhibit 8. It'll be, once you're there, go to page 65. Date stamped PLTF 000065. At the very bottom, are you at that page?
Yes.
Okay, at the very bottom, under conversation marked pickup, you state to her, Emma has advised that you plan on taking her to Vegas. Please advise us if this is true. And you go on and you address your concerns about COVID, correct? Can you turn to the next page? You read to us what her response is to that request, to that issue.
As well, Emma and I live in Vegas, so I'll be returning to our home. All proper precautions have and will continue to be taken. My mom will be returning with me and watching Emma if and when the governor deems it safe for us in the dental industry field to return to work.
Okay. And in accordance with the court's orders, you were supposed to return Emma to Ms. Bao on April 2nd, is that right? On April 3rd, I'm sorry.
Sure, I don't know the date, but okay.
Okay. On April 2nd, you told Ms. Bao that you would not be returning Emma to her. Do you recall that?
Yes.
Okay. And in fact, you did not return Emma to Ms. Bao that day, correct?
Correct.
You did return Emma to Ms. Bao the following day, right?
No.
In fact, nearly 2 weeks went by before you returned Emma to Ms. Bao. Isn't that right?
Yes.
And that was only after Ms. Bao had to hire an attorney and obtain a pickup order from this court, right?
Yes.
Okay. And when Ms. Bao asked you, after the pickup order was issued, to return Emma to Las Vegas, you told her no. Ms. Bao, you have to come to Missouri to get Emma, right?
Completely incorrect.
Oh, okay. Give me 1 sec.
Sure.
Court's indulgence, Your Honor.
Take your time.
We'll move on. So it's your position that you did not ask Ms. Bao to get Emma from you in Missouri, is that right?
I believe all that discussion was made by the attorneys and I didn't have her input. She claimed she was driving out, so that's what she did.
Okay. And you certainly didn't offer to fly Emma back, correct?
The offer was already made for her to drive, or she already said she was driving out, so no, I didn't.
When did she say that to you?
All right.
When did she say that to you?
I don't think it was during a court hearing. If you have access to pull it up, I'm sure you could.
Okay. pickup order from April 14, 2020 contains the following findings of fact. That father unilaterally relocated to Missouri without mother's permission or court order. That father refused mother's request to return the child to Nevada to exercise her custodial rights in accordance with the orders of this court. You never appealed that order, correct?
No,
And you never moved to set aside those findings of fact, correct?
I didn't have an attorney and I didn't know how to do it, so no.
Okay. And it was only after that you filed your motion for relocation, correct?
Yes, sure.
Okay. Emma returned to Las Vegas April 15th, and you'd agree Emma has spent the majority of the time between April 15th to today here in Las Vegas, right?
Not without me trying to get her, but yes.
You haven't paid any child support in the meantime, have you?
No.
I have no further questions, Your Honor.
Mr. Kelleher?
Yeah, just response. And one thing, Your Honor, I wanted to make clear, and I apologize, the court's absolutely correct that the tape of my client with the in-person of their daughter would not be hearsay. What my concern was is that by introducing that, we'd be opening a can of worms for everyone to claim what the child said or didn't say. So that was the concern. That's why we didn't put it in. Moving on to these, to the questions I have for you. Over the last number of years, sir, have you been earning how much per hour?
Between 18 and 20?
Okay. And over the last number of years, you guys have shared joint physical custody since the judge's order, Judge Brown, in 2018?
Correct.
And you've seen her answers to interrogatories and other discovery as to how much she makes an hour, and how much is that?
She was like 48, 47?
Okay. Has she paid you any child support in the last number of years?
No.
Has there been any order issued by Judge Brown since 2018 until the present for either party to pay child support to the other?
No.
Okay. And when you appeared in front of the court with your attorney in April of 2020, did the judge, did the issue of child support even arise?
Not that I can recall.
Okay. Let me ask you a little bit about this UNLV co-parenting. Is UNLV co-parenting open to even do classes?
I don't think that this last year at all, no.
Okay, so just to your knowledge, was that something that you looked into doing?
Yes.
Okay, and was it open and taking any enrollees at that time?
No.
Objection, Foundation.
Well, respectfully, Your Honor, I'd ask the court to take judicial notice that UNLV co-parenting has been closed since right before the pandemic struck, and ever since.
That's not appropriate for judicial.
I have not seen that information. I'm not sure that that's appropriate for judicial notice.
I'm not sure council can hear me. Prior to the microphone is turned on? It's on. It's on. You can't hear me? Can council hear me?
I can hear you now.
Okay, so I don't think council could hear me when I was speaking earlier. Let me take my mask down. When Mr. Kelleher was speaking about judicial notice and his request for the same, the court had sustained the objection of Mr. Ackerman. If you'd like to ask your client questions and lay some foundation, that would be appreciated.
You're looking at taking UNLV co-parenting classes since 2019?
Yes.
Okay. Did you just have discussions with any person about those parenting classes?
I might have, I can't remember, but I did go online and look.
Okay. Did you also, what discussions, if any, did you have with our office without revealing what was discussed about those classes?
But if it's in the order, I should probably take it. Remember, I've had so many discussions.
Were they being offered?
Not at the time, no. Oh, and I will come back around to it when it was available again or something.
To your knowledge, are they available now?
Not to my knowledge.
Objection, Foundation.
It's the same foundation, Your Honor. He's telling you that he's investigating it by going online and talking to him. Right?
It would be best if you did lay a little bit more foundation, Mr. Kelleher. The court can't take judicial notice of,
No, I understand it, Your Honor. I just don't know what else I'm at a loss, and I'm probably just being very inartful. I don't know what more you can do than have your client look online, phone calls, and then have our office do the same and be told that classes aren't available. Like, I don't know how else to lay the foundation but that.
okay.
Well, Your Honor, when was it
Inviting the court, I'm
that?
respectfully, as an officer of the court, I'm inviting the court to check it. If, you don't have to take my word for it. They haven't been offered in 2020.
Okay. I understand that council's frustrated, you know, I've been there. We could take a break and call UNLV.
Your Honor, in the interest of time, it's been 2-3 years now since it was ordered. If he's saying that he looked just prior to filing his motion or between filing his motion and today, we'll agree that he's looked after the motion was filed.
In terms of your salary, your income, what opportunities, if any, have you had prior to this job offer in Missouri to make $100,000 a year?
Absolutely none.
If a job had been available to earn $100,000 a year, would you have taken it?
In a heartbeat.
What were your feelings when you were approached about a $100,000 a year job in Missouri?
I really wanted to take it, but I wasn't sure how to proceed with it. So, I mean, it was a 6-month process before I actually, well, I'm sorry. It was a process in order for me to actually consider it.
You were asked about some paranoia that you have, for instance, physical issues in terms of your daughter's ankle.
Mm-hmm.
Do you remember that testimony?
I think so.
Okay, and you were specifically asked about a parenting or talking parent message that you sent accusing her of perhaps making up this injury. Do you recall that?
Yes.
Okay. Why did you feel that way? Why do you have that concern?
If you look over the history of the case, a large portion of her complaints regarding medical throughout the history of the case has always turned out to be false. So much so that it was specifically brought up in a Missouri court order several times.
Was Child Protective Services ever involved in that?
Yes.
Objection, Your Honor, as to relevance.
I'd like to hear the response. I think it's highly relevant if CPS was involved, and I think the question was a yes or no answer. So what's the answer?
Your Honor,
What was the nature of the CPS complaint made?
I think the
That I had sexually
was
abused my daughter.
Hang on, counsel. I think
Was that investigated?
She sings.
I'm sorry.
Hang on, counsel. I think I just need to speak louder. It sounds like your question was CPS involved, which was yes or no. Mr. Ackerman objected to that. I overrule it for the court's record and for the minutes, and then his answer was yes. And then I think
Correct.
Mr. Ackerman had a second objection, and then I didn't hear it.
yes, Your Honor, as to foundation, when did this take place?
Sustained.
Respectfully, Your Honor, I can lay that as I go along.
Sure,
So,
let's do
so I
it.
asked whether there was, and then you said that there was, and I said what was the nature of the complaint, and then my next question will be, when did it occur?
Okay.
Mr. Baptista, what's the response?
Oh, I'm sorry, I wasn't sure if I was supposed to answer yet. That was in 2014, I want to say.
I renew my objection as to relevance. All of this was litigated twice over now.
Well, respectfully, Your Honor, he's opening the door and making this an issue in the case, right? He's claiming that my client is somehow paranoid about actions made, and we're allowed to show the court why he may feel a certain way, and the basis of that.
Any further objection?
Yes, Your Honor. Under McMonagle, the Supreme Court has already ruled on this issue. Things proceedings having taken place prior to the last orders issuing custodial orders are not relevant for proceedings as to what has changed to warrant the modification of custody.
Any response regarding Nance versus Ferrero as to exceptions to the McMonagle rule, counsel? Or Castle v. Castle?
Yes, Your Honor, we're saying that this is an ongoing problem, that her lack of responding to him, her lack of allowing him to have the visits and the calls as was court ordered, has led to some frustration on his part, we agree, but that this is an ongoing concern for him, and that the April incident was just more of the same.
This would be an ongoing issue if CPS had been called over and over again, but that's not what's being presented.
With regard to the McMonagle versus McMonagle argument, I think that if something is from 2014 in this case, which has been heavily litigated and appealed almost immediately after there was a decision made, I'm not sure that I'm hearing something that would rise to the level of a Nance v. Ferrero exception to McMonagle. Examples would be domestic violence, convictions for domestic violence, more than just an arrest, some sort of abuse and neglect that was substantiated. Are anything like that something that Mr. Kelleher would be arguing pursuant to Nance v. Ferrero?
Pursuant also to Castle v. Simmons, the issue is if you have an ongoing pattern that undermines you as a parent, you're allowed to raise that. It wasn't limited solely to domestic violence, as the court knows. And what we're arguing here is that they're claiming he's defensive, right, about allegations of injuries taking place during his time, and we're just showing the court why.
So your argument is just that it's a pattern?
Correct. Exactly.
Okay. Mr. Ackerman, any response?
Yes, Your Honor. They're not arguing that it's a pattern. There has been no accusation against any wrongdoing by Mr. Baptista at any point. The messages that they point to do not accuse Mr. Baptista of anything. They simply say, I'm taking the child to a doctor. If what we were doing was accusing him of some type of wrongdoing, then I can understand pointing to those past issues where he had been accused of things then, and then we'd be talking about relevant patterns here. But they're not pointing to a pattern. They're pointing to one incident. He responded inappropriately, and they're saying, well, he should somehow be excused for that, and using that to open the door to things that have been litigated over and over again.
I tend to agree with Mr. Ackerman, Mr. Kelleher on that issue, but if you have something to question him on that establishes a clear pattern or some sort of, conviction or something else that's really relevant, let's hear about that. Let's move on. Both of your microphones are muted, gentlemen.
Sorry, that was my fault, I bumped it.
What impact, if any, did the appeal that you made in 2018 have on your job offer that you received in 2020?
Absolutely none.
Did you have any idea as to when the appeal would come back down from the court?
I had no idea the appeal was ongoing at the time.
Okay. And you're saying you didn't have any idea it was on. Between 2018 and the decision that came down from the appellate court, were you following all the court orders?
I was.
And everyone was getting their time?
Correct.
If the court says that you can't relocate Emma, the court finds that she's better off here, living here in Las Vegas, Nevada. What are your plans in terms of your living situation
I actually don't plan on moving back. I just can't see how that would be beneficial to anyone. Now with the money I make, the house that I live, the positions that I'm finding myself being open, doors that are opening up for me. I've been doing security in this town for many, many years, and I have never made this type of money and been able to provide this type of lifestyle for my family.
And you've provided those tax returns showing that.
Yes.
No further questions, Your Honor.
Any cross, counsel? I think you're muted, Mr. Ackerman.
You're right. No further questions, Your Honor.
Okay.
Your Honor, we call Ms. Christy Val.
And quick question for counsel. I have a 2-hour time slot certain Fridays. Would you guys like a 2-hour time slot to make up that 45 minutes I owe you?
Well, respectfully, we may not need that.
Okay.
And I believe Mr. Kelleher's right. I'm not going to have too many questions. I think we can finish up. However, if we get there, I would appreciate the extra time necessary.
Okay. Thank you.
Ms. Ball, could you please state and spell your name for the record?
Christy Ball, K-R-I-S-T-Y, B-A-N-G-H.
And you've already been sworn to testify, is that correct? You've already sworn in?
I have it.
No.
I have it.
Okay, I'm sorry, Ronnie, she needs to be sworn in.
Yes, we're going to swear her in right now. Thank you.
Please raise your right hand. You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can raise your hand down. You can put your hand down, and please state your name and spell your first and last name for the record. Thank you.
Thank you.
Christy Ball, K-R-I-S-T-Y, B-A-N-G-H.
My
Ms.
clerk
Ball, I
has the
understand
most
that-
pleasant speaking voice, doesn't she? The most pleasant speaking voice. Please proceed.
Ms. Ball, you're currently working as a dental hygienist, is that correct?
Yes.
And that's the same work that you did in Missouri, is that true?
I did not work in Missouri.
You were a dental hygienist in Missouri?
Not in Missouri.
When the court made its order in Missouri in 2000, I believe it was 16, was it 16 or 17, do you recall?
2016?
Would it be fair to say that after the court made its order in Missouri, you relocated to Nevada within about 8 weeks?
No.
How soon after the court made its order did you relocate to Nevada?
4 months.
And in terms of this court's rulings today, if the court orders that Emma would relocate to Missouri, you would go and move to Missouri, isn't that true?
No.
Isn't it fair to say that you've told your ex, the father of your child, multiple times that you'd like to move back to Missouri?
Not multiple times, no. I believe there was one conversation.
And in that conversation, isn't it true that you told him you'd like to move back to Missouri?
I said I would like to move back closer to home, but I never quite said Missouri.
Okay. So, well, what is home then? Isn't home Missouri?
It is, but I would not move back to where I'm from now.
But you moved back to Missouri, but not to where you're from, which is where in Missouri?
Carthage.
If Mr. Batista lived in Carthage, Missouri, rather than Nixa, would you in fact move there if the court ordered a relocation?
No.
But no family that lives here in Nevada, correct?
No.
What family do do you have that lives in Nevada?
I don't have anything with her.
Okay. And I know that you answered some discovery in this case. I just wanted to ask you about the family that you have that lives in Missouri. And I'm looking at page 5 of your interrogatory response. I just want to ask you if the following people live in Missouri. Sean and Debbie Bow, they live in Carthage, Missouri, is that right?
Yes.
And that is your mother and father?
Yes.
You have your sibling Tricia Thomas and brother-in-law Michael Thomas that live in Springfield, Missouri, is that right?
Yes.
And is Nixa in Springfield, Missouri?
It is next to Springfield.
Okay. And isn't it true that you have a family member who is a teacher in Springfield, Missouri?
Yes.
Okay. And is that Tricia?
Yes.
And what grade does Tricia teach in Springfield, Missouri, in the elementary school there or the school there?
She's a kindergarten teacher.
You also have Bob and Lara Ford in Webb City, Missouri, is that right?
Yes.
And how far away is that from Springfield or Nixa?
About an hour.
Okay. Then you also have Pat and Eldon Mizzy in Joplin, Missouri, is that right?
Yes.
Okay. Would you consider yourself close to those family members, Pat and Eldon Mizzy?
Patton Mice. Yes.
Apologize for mispronouncing.
Yes.
Marilyn Bow, who's Marilyn Bow?
Marilyn Ball is my great aunt.
Okay, and she lives in Carthage?
Yes.
And Joe Bow lives in Carthage?
Yes.
Loretta Huff lives in Junction, Missouri, is that right?
Carl Junction. Yes.
Okay. And Bridget and Rob Yust, they live in West City, Missouri?
Yes.
And you also have Rocky and Eileen Ford that live in Missouri?
Yes.
And they live in Neosha, is that how you pronounce it?
Yeah, Neosha.
Okay, how far away is that from Nixa?
I wouldn't know exact because it would depend on which way you go, but it's about 40 minutes from Carthage where I'm from.
Okay. And then you have Kyle and Ginger Bow that live in Carthage. And you have Tasha and Larry Hardy that live in Junction, Missouri, Carl Junction, Missouri. Is that right?
Yes.
Okay. And then you also have Karen and Kyle Olson that live in Carthage, Missouri. Is that right?
Yes.
And Lucas and Andy, they all live in Carthage, Missouri.
Yes.
And how about Kathy and James Jordan, Dylan, Sampson, Carson, and Faith? They all live in Missouri. Is that right?
Yes.
And Sky and Joe Farthing and Arden and Della, they all live in Salem, Missouri?
Yes.
Okay. And Ashley and Matt Montgomery, Roslyn and Ellery all live in Missouri, is that right?
I believe they're on Missouri side. They're like Kansas.
You have put down that they live in Missouri. Is that wrong?
I think it is. I know they just moved.
Okay. Then Caitlin and Chaz Stennett, Etlin and Elsie, they all live in Branson, Missouri?
Yes.
And then you have Adrian, Amber, Gracie, Ella, Adalyn, and Briar. They live in Missouri too?
Yes.
Okay. And Miranda, Oxford, Tatum, and Levi all live in Missouri. Is that correct?
Yes.
And Chelsea Harding lives in Missouri. Is that true?
Yes.
And then you have listed that in addition to all the people that we just went through, that you also have extended family that lives in Carthage and Joplin and Kansas area. Is that correct?
Yes, I have a very large family.
Okay. And all that large family all lives in Missouri, or perhaps right on the border of Missouri. Is that right?
Yes.
Okay. Would it be fair to say that the only reason that you moved to Nevada was because the court in Missouri had determined that once MS started school, she would be beginning school here in Vegas. Isn't that true?
Yes, I moved there.
You had mentioned earlier that you consider Missouri home, right?
Yeah, I was home.
Okay. And isn't it true that you encouraged Mr. Baptista to take this job in Missouri. Isn't that true?
No.
Isn't it true in the Talking Parents references that you indicated that you were going to think about it and that you were happy about Missouri?
No, I don't recall saying I would think about.
Well, we were here when I walked through those Talking Parents exhibits,
Yes.
Big Stamp 395, and you don't recall having said that that you were happy about Missouri?
I would have to read there, to be honest with you. I don't remember my exact words.
Have you discussed moving to Missouri with your mom?
No.
So I just want to make sure that your testimony under oath is that your mom came out here since about August of 2020 to care for Emma while you're working. Is that true?
Yes.
Okay. And the only reason that she's away from Carthage, Missouri is because of your request that she help you with Emma. Isn't that correct?
Yes.
Okay. But your testimony under oath today is that at no time have you ever discussed with her moving back to Missouri. Is that correct?
Correct.
That she'd be really happy if you moved back there. Is that true?
Objection. Seeking hearsay and speculation.
Sustained as to speculation.
Let me ask you this way. Have you discussed it with any of your family members? All this 1.5 pages on your interrogatory response. Have you talked to any of them about moving back to Missouri?
No.
And isn't it fair to say that in the last 24 months, you have lived at multiple addresses? Isn't that correct?
There's been 2 or 3.
In your answers to interrogatory, you listed 3 different places in under 2 years. Is that correct?
Yes.
Okay. And in all 3 of those places that you lived in the last couple of years, or within the last couple of years, they've all been rentals. Is that correct?
Yes.
And one of the things that you had indicated in your Talking Parents is that your lease was to run out in September of this year. Is that correct? Or I'm sorry, September of 2020. Isn't that correct?
Yes.
Okay. And what is your current lease status right now?
And this is the September of 21.
And it would be fair to say that you visited with Emma to Missouri on 3 to 4 occasions per year. Isn't that correct?
Yes.
And Emma likes it in Missouri. Would that be fair to say?
Objection. Speculation.
Wouldn't be speculation. I'm asking of her own personal knowledge.
Sure. To speculate what Emma would like.
And ask what she likes. I'm asking her that she likes Missouri, correct?
Would
So that's everything.
My objection.
counsel like the court's decision? The court's decision is going to be sustained as to speculation. However, mom is free to testify as to her observations and opinion as a mother. She's free to testify to that.
Well, let me ask it this way. You would only do things that you feel like are in Emma's best interest, correct? Would that be fair to say?
Yes.
Would you agree with me that if Emma didn't like going to visit in Missouri, you wouldn't take her there multiple times per year? Isn't that true?
Yes.
Isn't it true that without speaking to Mr. Batista, you enrolled Emma in the hybrid program at the Legacy School on the first day that they allowed for that option to be done? Isn't that correct?
No.
Isn't it true that you enrolled her in the hybrid classes when there are other options available without speaking to Mr. Baptista? Yes or no?
Objection. Compound.
Can you point us to anywhere in our family wizard, in Talking Parents, because I've read through all those, where you contacted him and told him that you were enrolling Emma in the hybrid program in June of 2020? You show me any piece of paper or any kind of indication where was the case?
Not in Talking Parents, no.
And the truth is that's the only way that you guys communicate, isn't it? Is through Talking Parents, isn't that correct?
Yes.
Okay, so nowhere in Talking Parents is there any indication that you notified him or asked his permission in any way to enroll Emma in the hybrid program, isn't that correct?
Correct.
You made that decision unilaterally, correct?
No.
Well, we can make the decision besides you.
We discussed it in the June 24th hearing.
Okay. Isn't it true that you had already enrolled her in that program prior to the hearing, any hearings in court? Isn't that true?
I couldn't. The hearing was on the 24th and it didn't open until June 30th.
I'd like you to look at what would be Exhibit S, if you can go to Exhibit S.
Very open, please.
Look up Exhibit S.
So was that S as in Sam?
I don't have
Was that S as in Sam?
Yes, S is in Sam.
While we're in a lull, real quick, I just want to state something to both council on the record. I went to the UNLV Cooperative Parenting class schedule, and it says there are no scheduled sessions at this time. Sign up to be notified when this course is available, and there's an email address box. I just wanted to let everybody know. Thank you.
Well, I had to change her this morning, then, Roger, because I called her.
Okay.
So, let's look at Exhibit S. And I just want you to take a look at that yourself. And there's no question that you were the one that signed up for the hybrid program. Is that correct?
Correct.
And what was the date that you signed up for the hybrid program?
June 30th, 2020.
And in terms of your employment, what is your rate of pay right now?
$47 an hour.
And my understanding is that you have one full-time job at Welch Dental, is that correct?
Yes, Welch Dentistry.
Okay, and then you also, in addition to that, pick up extra hours at a different entity, is that correct?
No, I would say that I do not know.
Okay. When you answered your interrogatories, though, you were still doing that, is that correct?
No, unless I just wrote it wrong. No, I've been at Welch Dentistry exclusively since May of 2020.
Prior to your mother moving out in August, let me strike it. Did your mother go back and forth to Missouri, or is she full-time? Has she been full-time with you since August of 2020?
She has gone back and forth a few times.
How often has she gone back?
Whenever I went to Andrews for the month of November and over Christmas.
Okay. So whenever Dad has Emma, your mother returns to home in Missouri, is that right?
Yes.
So is the long-term plan then that if the court says, no, Emma is not going to go to Missouri, that's not better, is your mom going to stay living with you here except for the times that Dad has Emma?
No.
Okay, so you're going to go get back to having other babysitters, is that correct?
I I can't answer that right now. It's a hypothetical situation. I don't know what will happen.
Well, let me ask it this way. Prior to August of 2020, you were using daycare providers, isn't that right?
Yes.
Okay, and who were the daycare providers?
I use Legacy Kids Care, which is the program in our school for before and after school. And then on the, okay?
Go ahead.
On the day that extended family hours, I used 5-Star Sitters, which is a babysitting agency.
Okay, and you would agree with me that you were often dropping your daughter off in the mornings at 6 o'clock in the morning, isn't that correct?
Yeah.
What time in the morning did you drop your daughter off at school prior to your mom getting here?
At 7 a.m.
And then what time was she staying there for aftercare until what time at night?
On the nights that she made it aftercare, she usually had a babysitter because it extended beyond the hours.
Okay, so who would pick her up if it was beyond the hours that were permitted by the school? Who would pick her up then? Would the babysitters pick her up?
Yeah, they picked up that drive-in.
So, I just want to make sure I understand it. Prior to August of 2020, you dropped your daughter off, according to you, at 7 o'clock in the morning, and then the babysitters would pick her up in the afternoon from school and keep her until you got home. Is that correct?
No, okay, so on Mondays and Wednesdays, I would work 9 to 6:30. On that day, the babysitter would pick her up after school and keep her. On Tuesdays and Thursdays, I worked 8 to 3. So I would drop her off at 7 and I would pick her up after school.
But either way, so on some days, you would drop her off at the babysitter, at the pre-care, right? At 7 o'clock in the morning, even though you didn't work until 9? Is that
No,
correct?
I would 8 to 3 on Wednesdays. And I worked across town.
And then the babysitters would have her, is that correct?
On those days.
On the days, sure, on the days that you were using the babysitters, right? They would pick up at school?
Yes.
Okay. What drove the decision to change to have your mother come out and then provide the care starting in August of 2020? Was it this case?
No, it was the unknown of whether they have Legacy Kids Care or not, and what was going to go forward with school with this pandemic.
So as you sit here today, then the plan would be that your mom will just continue to live with you and provide this care at any time Dad doesn't have Emma. That's the plan right now, correct?
For the time being,
And you never tell Andrew that you weren't required to give him any information about the babysitters that were involved.
not to my knowledge.
You'd agree with me that there was a court order that says that neither parent was to obstruct the other parent's phone or video time with the child. Isn't that correct? You're
Yes.
aware of that, right?
Yes.
And isn't it true that your mother monitors the phone calls between Dad and Emma? Isn't that correct?
No.
Isn't it true she's sitting in the room when he makes these phone calls? Isn't that true?
She may be in the room at some point, but not all the time. No.
Isn't it true that you yourself were also monitoring these phone calls, sitting right there, and sometimes answering for Emma instead of Emma answering? Isn't that true?
No.
Let me ask you this. In terms of this case. If the court allows Emma to live full-time in Missouri, what kind of visitation would you want?
They just do the operating energy of breaks in the summer and holidays.
Isn't it true that you wouldn't allow him to have any time in Missouri when you say it's the same that you're offering? Isn't it true that you had to go to court several times because you refused to let him have any visitation outside the state of Nevada? Isn't that true?
No.
Isn't it true that you would not permit any visitation outside the state of Nevada until we filed yet another motion with the court, and the court said, okay, he can have visitation out in Missouri? Isn't that correct? Isn't that true?
Mm-hmm.
No? Okay, so then, after April of 2020, tell me when you offered him out-of-state visitation without a court order.
I didn't offer him.
Okay, and isn't it true that he was asking for time in the summer without any court order to have visitation in Missouri, and you resisted it? Isn't it true?
In the summer?
The summer of 2020, yes.
Yes, I did at that time.
Okay, right. And in fact, he had to file several motions to get visitation outside of the state of Nevada. Isn't that correct? Isn't that true?
I think he filed one for the summer, yes.
Well, did he have to file another one to get visitation in October and November of 2020 in Missouri? Didn't he have to do that, and the court issued an order on that? Isn't that true?
Yes.
Okay, so you resisted. So what you say is that you know that you were resisting any visitation in Missouri, correct? Isn't that true?
I would not say I resisted any.
Okay.
I resisted being in school.
Okay. Well, she wasn't at school in the summer, correct? Isn't that true? Okay, and isn't it true that you fought any visitation in the state of Missouri in the summer even when there wasn't school? Isn't that true?
Correct.
Okay. And you agree that whatever affidavit you filed with the court and the pleas you filed with the court, that was done with the assistance of legal counsel, correct? Isn't that true? Okay. So you agree that you're bound by whatever your attorneys represented and what you signed under oath at that time, correct?
Correct.
Isn't it true that you accused my client of over-parenting Emma because he wanted to become involved and was involved in the parent-teacher organization? Isn't that correct?
Can you repeat? I don't understand.
Sure. There's a parent-teacher group, isn't there, at Emma's school?
Yes.
And isn't it true that you accused my client of being an over-parent by joining that group and participating?
No.
Isn't it true that you signed up, Emma, for the Mozart section without speaking to Dad about it? Yes or no?
No.
I'd like you to look at, it'll be Exhibit AA. I'd like you to go to Bait Stamp 360.
You said 360, counsel?
Yes, you're on AA 360. I'd like you to show you this right here in the middle, 7/27/2020 at 8:13. Says, and I was never notified by you of Emma being enrolled in the Mozart program at Legacy. I had to receive an email from the school. Any other information I should know, such as details of the program. Do you see that?
Yes.
Okay. Did you in fact sign Emma up for the Mozart program at school?
Yes.
Okay. And when did you sign her up for the Mozart program at the school?
It was a selection for the enrollment from the previous year.
Okay. When? Okay. Try my question. When did you sign her up for the Mozart program?
I don't remember the date. I just know it was the previous spring.
Okay. And can you show me anywhere in any of these documents you know this has been an issue. Can you show me anywhere where you informed him that you had signed her up for the Mozart program?
Specifically, no.
And can you show me what your response was on bait stamp? Look at bait stamp 360 and 361. Tell me how you responded to him as to the Mozart issue and the orthodontic issue. How did you respond?
Are you wanting me to read that?
Well, just tell me when you did respond.
I'm not sure if the Mozart program, which is part of the school curriculum, you have all access to the same school and private ID. Not sure how you're being involved in that track would affect any visitation and you should not be using it during school hours.
So, pretty much an admission on your part. Would you agree that you didn't inform him? Isn't that true?
Sure, yeah.
Okay. Well, you kind of look like you're perplexed that I would ask a question like that. Wouldn't it be fair to say that if he enrolled your daughter in various things and didn't tell you, you'd be upset? Would you agree with me with that statement?
I would be really not so much upset.
Okay. You'd be annoyed rather than upset. Would you send a text message and ask for the information? Would you send a talking parents thing and ask for that information?
Yeah.
And would it annoy you if the response back was, oh, well, that's information that if you just go on at the education at the school, you can figure it out for yourself. Would you be annoyed with the response like that?
No.
Okay. That's your best testimony under oath today, correct? Is that you wouldn't be annoyed if that was the case?
Objection argumentative.
I didn't hear counsel's objection. What was it, please?
Argumentative, Your Honor.
The actual
Counsel,
objection
the
would be
decision is
that
overruled. Please continue.
isn't it true that Emma was getting bullied at Legacy?
Yes, there was one instance.
Isn't it true that you confronted one of the parents about it?
Yes.
And isn't it true that you wanted your child in therapy because of some of the problems she was having at the school?
Yes.
And isn't it true that Mr. Batista was against the Legacy school and he wanted her to remain at the Wright school? Isn't that correct?
No.
Isn't it true that you enrolled Emma in the Legacy school initially without talking to my client? Isn't that correct?
No, I did not even know how you got talking to him.
No. Isn't it true that you never got his permission to enroll? You simply told him that you had enrolled her. Isn't that correct?
No, I have not enrolled her.
Objection as to relevance. This has been litigated already.
Well, respectfully, Your Honor, it's an ongoing pattern of non-cooperation, as you can see in these messages, and you're being left with a decision today, as the courts were previously, as to which parent can be relied upon to help co-parent and not be a gatekeeper. It's right at the heart of the case.
I think it goes as to best interest factors, and I'm okay with having some testimony about it. It's a little confusing how counsel is asking about it, so if we could get a little more information, I think that would be appropriate. Thank you.
Well, let's look at Bates. Let me ask it this way. Isn't it true that you went to a parent-teacher conference in September of 2019 and you didn't notify Andrew that he could attend or to the existence of it? Isn't that correct?
It was not a parent-teacher conference, no.
I'd like you to look at Bates stamp 429. This is Exhibit AA 429.
Okay.
You share joint legal custody with Andrew, isn't that correct?
Yes.
you see there where he's asking you about this incident with the school? At the top of the page?
Yes.
Okay. Did you respond to him?
No.
Isn't it true that you also don't respond to him?
Yes.
I'd like to look at base stamp 366. It's AA, Your Honor. All this is an exhibit AA.
Thank you, counsel.
You agree with me that joint legal custody means that you're supposed to inform one another of doctor's appointments and other things like school events, important issues, correct? Right?
Yes.
It's a two-way street?
Yes.
Okay. I'd like you to look at 366, base stamp 366 at 7:14 p.m. You just read what you stated.
It was ordered to be campus. You should have video of your copy. I picked my copy up, or my copy. I do not believe it is my job to get school information for you. I suggest you contact the school and see if it's still you not manage your copy. I will make sure you have updated your home address with them.
Okay. And at that point, you had the information, correct?
Yes.
Okay. And it would have been no big deal for you to have just copied that information, taken a picture of it or whatnot, put it in Talking Parents and send it to them. Isn't that true? Correct? And I just, yes or no, do you believe that your response on base stamp 366 would be an example of the kind of co-parent that you are, joint legal co-parent that you are?
No.
Okay. Would you agree with me that you would be expected to do a little bit more than what you're indicating on base stamp 366? Isn't that true?
You would be expected to do a little bit more? Is that what you said?
Yes.
Yes.
You agree that Mr. Batista had the final decision on all medical issues, is that correct? By court order dated April 25th of 2018, isn't that correct?
Yes.
And isn't it true that he asked you to FaceTime during these various doctor's appointments in April of 2020, isn't that correct?
Yes, I'm going to.
And on none of those occasions did you FaceTime, correct?
No, I did. Every time I did anything, I did.
Rather than go through all the base stamps, which I can, you don't disagree with the various base stamps showing that you didn't FaceTime on some of these appointments, correct?
Correct.
Take a look at base stamp 378.
Mr. Kelleher,
Yes, Your Honor.
I didn't quite understand what Mom's response was about FaceTiming during the doctor's visits. I'm not sure if there was a problem with your audio at that time, but it sounded really muffled, and I don't know what the witness's response was. Would you mind asking those questions again?
Sure. Ma'am, there's no question that Mr. Batista asked you to FaceTime all of these various appointments for your daughter in April of 2020. Isn't that true?
He asked me to say it, and he didn't.
But on none of those occasions did you FaceTime him, correct?
I did on some of them, and I didn't on some of them. There was a couple.
Well, the only ones we have proof of are the ones here that show that you didn't do it, correct? And because when you strike it, everyone agrees that the level of communication between the two of you is not good. You agree with that statement, correct?
Correct.
All right. And all of your communication goes through Talking Parents, correct? That's what you told me earlier. Is that correct?
Yes.
Okay. base stamp 377, where we're talking about Emma's ankle, all right?
Yes.
And it says, Emma told me she jumped, fell/jumped out of a tree at your office. Do you see that?
Yes.
Okay. And did you also indicate to him that she had, later, that she had in fact had a fracture? Isn't that correct?
Yes.
Okay. But the truth is, when we got the medical records, there was no fracture. Isn't that true?
That was a different doctor.
Well, whatever doctor looked at her, the doctors all concluded she didn't have a fracture. Isn't that correct?
I don't know how to get up a grade from that, sir.
Let's look at Exhibit U. Where I would ask you to go to Exhibit U.
What page number by chance?
Sure. Exhibit U, base stamp 302.
Mm-hmm.
And then I'd like you to go down to the middle of the page. It says lab test results. Right? Right there it says no fracture. Right?
Give me 1 second, sir. That is not the office we were at on this one.
I'm not asking you to explain to me. This is the doctor that did the X-ray and said no fracture. Isn't that correct?
Yes.
And isn't it true that this was the medical records that you wouldn't provide to my client? He had to go get them himself. Isn't that correct?
I'm confused on which day you're talking about, because there's 2 different appointments.
You know what? We'll make it really clear to you. Here's what we're saying, so that you'll kind of understand where we're coming from. You claimed that the child fell out of a tree. Supposedly told you that. Days later, after you got her, you take her to a doctor, and you're claiming that she had a fracture on her ankle while she was in Dad's care. Do you agree that you made those statements in talking to parents? Yes or no?
Yes.
Okay. And then, without allowing my client to attend the appointment or giving the information, when it was investigated, she had no fracture in her ankle. Isn't that true?
No.
It's not a medical record. So no, she didn't have a fracture. Isn't that true?
From this paper, this is a different appointment. This is what he says. That's why I'm confused.
Isn't it true that on May 18th there was a follow-up appointment where all this would have been cleared up in terms of her not having a fracture, but you didn't let Andrew participate in that doctor's visit either. Isn't that true?
May 18th. I don't believe it was on May 18th.
But you know what? It's good anyway. It's AA, base stamp 370. Isn't the truth that whatever happened to your daughter, to her ankle, it was actually on your time? Isn't that correct?
No. Did you say 370?
Yep, base stamp 370. I'd like to see, let's look at the middle of that page, base stamp 370. We've had a hard, this is from you, right? Andrew, we had a hard time getting appointments with Jackie. However, she got an opening today at 2 p.m., so Emma will be having a session with her at that time. Is that correct?
Yes.
Okay. And that's dated at, it's 5/18 to 11:25 a.m., correct?
Yes.
Okay. And then let's go to the next page on base stamp 371. And he asked you to do a FaceTime, isn't that correct? Is
Yes.
that true? Okay. Then let's go to the next base stamp, 371. Same exhibit, Your Honor, AA. Andrew, there was no point and no time to FaceTime. They took an x-ray to check her leg, and the doctor stepped in and said she's fine and to take it easy for a few weeks, and the appointment was over. Do you see that?
Yes.
And like I said, you asked to FaceTime on these appointments and you wouldn't let him. Isn't that true?
Objection asked and answered.
Overruled.
Not true, ma'am?
He's FaceTime on others, yes.
You would agree with me that the records, though, from talking parents would be best able to reflect those times, correct? You'd agree with that, right?
No, because there have been times I haven't answered and I'm still FaceTimed.
Would it be fair to say that at least half the time you don't respond to the text, to the talking parents communication he sends to you?
Yes.
And isn't it true that you took Emma to the Maple Leaf Festival on vacation in October of 2020? Is that correct?
Yes.
And you counted that as a vacation, is that correct?
Yes.
But isn't it true that just a month earlier than that, when Andrew wanted to fly Emma to Missouri to celebrate his birthday, you wouldn't agree to let him travel due to COVID restrictions, isn't that correct?
I don't remember being asked for him to go to Missouri.
All right, let's look at go to Exhibit AA. Date stamp 350 and 351. Oh, it has a big heading that says travel for my birthday, 9/7/2020 at 2:21 p.m. You see that?
Yes.
Okay, and I'll just read it to you. My attorney asked that I contact you first. I am purchasing a flight for Emma to come up here on the 18th. She will fly to Tulsa while I pick her up. The flight leaves at 1 p.m., so she would need to be at the airport no later than 11:30 a.m. She will return Sunday 9/20 at 6:30 p.m. See that?
Yes.
Okay. Now, does that refresh your recollection that he was asking for time?
Yes.
Okay. But will you accommodate this or no? The 1 p.m. flight is the only non-stop flight that gets here early enough to not lose the whole day. You see that?
Yes.
And he says, I would appreciate a response as soon as possible. Do you see that?
Yes.
And it's important for him to put that in there and he'd like a response as soon as possible because about half the time you don't respond to him at all. Isn't that true? Right?
Yes.
And then go to the next page. On 351 it says, is she flying by herself? Because at this time with the restrictions, I will not agree to that. Do you see that?
Yes.
Okay. And then down below, you said, I will inform my attorney of another refusal by you to co-parent besides how many times have you sent Emma as an unaccompanied minor? Another example of do as I say and not as I do. Do you see that?
Yes.
And yet, with all these COVID restrictions you were worried about, you were the one that wanted your daughter in school face-to-face half the time, right? Isn't that true?
Yes.
Okay. And isn't it also true that your daughter suffers from a malady that causes a different skin tone? Isn't that correct?
She has a condition I didn't agree that she suffers.
Okay. It doesn't cause any pain at all?
No.
Does she take medicine for it?
No.
Mr. Kelleher, in the next couple minutes, I'd like to give my staff a bathroom break. Feel free to ask some more questions, and we'll break whenever you think there's a natural breaking point, okay? In the next
Okay, thank you, Ryan. Thank you for that. I just have a couple and then I think I'll break it. You.
Sure, I don't want to interrupt your flow. Go ahead.
Isn't it true then that that Emma flew to Missouri to celebrate? I'm sorry, that Emma flew to the Maple Leaf Festival just the very next month. Isn't that correct?
Yes, she did with me.
And isn't it true that in the previous year, in 2019, on Andrew's birthday, you scheduled an appointment for Emma at the doctor on Andrew's birthday? Isn't that correct?
Yes, she did on his birthday.
And isn't it true that he was on his way over there to the appointment that you told him was going to be at 4:15 p.m.? Isn't that true? right? Do I have to go back to them? Okay. And the truth is, the appointment wasn't at 4:15 p.m. the way you said it was. She was out of there at 4:05 or earlier than that. Isn't that correct?
That is correct.
Okay. And he didn't get any time on his birthday, right?
No.
Okay. Because you prevented it, correct?
No.
Well, he was on his way over to an appointment. He was happy to take her to the appointment, but you said no, correct?
Correct.
And he was in charge of the doctor's appointments, correct? Isn't that true?
What do you mean in charge?
Well, you understand there's a lawyer in charge of who's in charge of medical, correct? You're aware of that, right?
When final decision making, yes.
Okay. And you took her to the appointment earlier and whisked her out of there so you couldn't get the visitation. Isn't that correct? Or any time with her? Isn't that true?
No.
Well, he previously had in 2019 and 2020, on both occasions he made efforts to have Emma with him on his birthday, and you prevented that both times. Is that true?
No.
On your end, this is a good time to break. I have no problem taking a short recess if this is good for the court.
And I just want to advise council that the court has read the Talking Parents messages that Mr. Kelleher is asking about, where there were messages from 3:07 p.m. where the child was already done with the doctor's visit, and then there's text or emails after that that says there's an appointment at 4:15, and then dad's upset because he thought he would be able to see her during the doctor's appointment, and then it looks like she completed the appointment at least an hour before that. So I did read that in Talking Parents, and I just want to let everybody know that.
Thank you, Your Honor. How long is the recess, Your Honor?
Your Honor, I do want to point out on that, the timestamps for when these conversations seem to take place don't appear to always be correct. So in one of those messages it appears that it's from 3:50 p.m. She's talking about the appointment is actually at 4 p.m. So the timestamps don't appear to match up with what's going on in the conversations. So I'm trying to look for that page now. I lost the page.
We can
That's
cover that on cross. I have a note on the page. We'll break for 5 minutes. 3:36.
Thank you.
Thank you.
Thank you, Your Honor.